So I'm so delighted to introduce two of the leading experts in America on this fascinating topic. We have Carrie Cordero, who's an adjunct professor and director of national security studies at Georgetown University Law Center, and my old friend and college classmate, Claire Finkelstein, who is a professor of law, professor of philosophy, and director of the Center for Ethics and the Rule of Law at the University of Pennsylvania Law School. We're also delighted to be joined by students from Arcadia University and Newman University. We're going to talk for a bit. We will have an energetic conversation. Please jot down any questions you have as they occur, and our wonderful town hall director, Robin, will be collecting them, and at some point we will break and start taking your questions. So we have two great issues to talk about today, and really I can't think of any two constitutional issues that are more important or more vexing. They involve both the constitutionality of ubiquitous drone surveillance, where police departments are increasingly using drone cameras to track individuals 24/7, and also the equally important but rather different issues raised by targeted killings. And we want to ask ourselves, what, if any, constitutional issues do these two forms of drone use raise? What are the arguments on both sides, and what do we think about it? So I want to begin with drone surveillance. I was at a conference at Google a while ago now, it was 2007, and the head of public policy at Google said he expected soon Google and Facebook would be asked to take live feeds from all the surveillance cameras in the world and put them live and online. And he imagined that if Google and Facebook were to do this and to aggregate the images and store them, then it would be possible to sign on to Google, say, click on a picture of anyone, say me, back-click on me to see where I came from, forward-click to see where I'm going, and basically have 24/7 surveillance of anyone at all time in the system. That vision, which he predicted was about 10 years down the line, is now much closer to being reality in a world where police departments are now using drone cameras to engage in that sort of ubiquitous surveillance, taking a particular suspect and tracking their movements 24/7. And also a world where soon Google Glass will become ubiquitous, and when you and I have a conversation, we'll have to negotiate in advance whether or not it's on or off the record and can be recorded, and whether I can stream the live feed onto the internet and be tracked. So broadly, Carrie, if you could, I just want to ask you, factually, what's the state of play with drone surveillance? What are police departments doing? What is the national security agencies doing? And how can we expect it to develop over the next couple of years?
Sure. Okay. Well, first of all, I just wanted to say thank you for having me here today, and it's great to be here with all of you on Constitution Day here at the Constitution Center. So it's a real honor to be here. So just to back up for a second, a couple thoughts, just to give you a little bit of background. So before I came to Georgetown, I was a national security lawyer in the government, with the Justice Department, and with the intelligence community. And so I tend to bring a practitioner's view and sort of perspective to some of the issues that we're going to be talking about today. So our conversation is about drones and privacy. And with respect to the drone surveillance, I think one thing that's helpful to keep in mind, both in terms of the law enforcement aspect, but also with respect to the targeted killing issues that we'll talk about in a little while, is that it's not necessarily the drone per se that is the issue. The drone is, you can describe it a few different ways, but you could say that it's a piece of hardware, it's a advanced technologically piece of hardware with respect to the targeted killing. It has a weapon on it, so it's a piece of weaponry. But what I think the conversation is really about is what is the underlying activity that the technology is doing. And it's the activity, both with respect to the law enforcement issues that we'll talk about, as well as with the national security targeted killing issues. It's the underlying activity that has the legal, constitutional, statutory, and then down the road, policy and ethical considerations. So currently, with respect to surveillance, drones are used in limited way. There was a recent, you may remember, there was a recent debate politically where Senator Rand Paul wanted to, actually was holding up the nomination of the new FBI director, Director Comey, because he wanted to know more about how the FBI was using drones in law enforcement surveillance. And the FBI sent a letter to him and responded. And what they said is that the FBI does use, so talking about federal law enforcement, they do use drones for surveillance. They do follow a variety of set of guidelines of how they use them. And Director, it was Mueller who under his administration, where they sent the letter before Director Comey came in, but they said they've used it in about, I think it was about 8 criminal cases and 2 national security cases since 2006. Now, they didn't provide the details for how those had been used, but the FBI said that they were providing some additional information to the senator under classified, in a separate classified document. And what I would expect that document probably contained would have been examples of the exact cases. The letter did give one specific example, which is useful to think about, which is the case in Alabama, I think it was earlier this year, where there was a 5-year-old boy who was held hostage. And in that case, the FBI deployed its drone surveillance, and that helped them complete a successful rescue operation. I think part of the reason that the conversation has focused on drones is because it's a new technology, but it represents sort of a broader conversation that I think the nation is having regarding what is our expectation of privacy. So when we talk about the activities of drone surveillance, what we're really talking about is the Fourth Amendment and what is our reasonable expectation of privacy, which is the test that was set out in the late 1960s by the Supreme Court. What is our reasonable expectation of privacy? And as we talk about these technologies, I think we'll be able to explore more whether or not there's sort of 2 different sides to the argument. One side is that in this digital world, with all these new technologies along the lines of some of the ones that you're explaining, the Google scenarios is, are we sort of abdicating some of our expectation of privacy because there's all these new technologies that we want to be able to use? The counter to that argument, and so the argument goes that we're sort of willing to let go of some of our expectation of privacy because we want the benefit of all this different sort of technology about how we communicate with each other, how surveillance can be conducted, all these sorts of things. The counter argument is that our expectation of privacy is the same. It really hasn't changed. And instead, what we need to do is we need to build on the protections to protect that expectation of privacy in the light of all of these new technologies.
Wonderful. It's beautifully summarized, great examples of what is going on, and you've teed up the constitutional debate very well. Before I ask you both to engage that Fourth Amendment debate, Claire, anything more to add about how these are being used and will be used in the next 10 years for surveillance purposes?
Yeah, I think one of the big challenges that we have is that we have extreme needs in the national security area. And those needs are, as it were, the tail wagging the dog of the surveillance that we struggle with domestically as well. So because we have been forced to or have to fight, in a sense, a war of information, we have to have the ability to acquire that information. Now, as in all areas in military ethics and in the ethics of national security, we have a series of policies that are blind with respect to whether or not we're dealing with Americans or we're dealing with non-Americans. And as soon as we're dealing with Americans, from whom we're trying to gather information, about whom we're trying to gather information, we run into constitutional issues that we don't have when we're dealing with non-Americans. So the big challenge as I see it, rather than specific to the technology, the big challenge that I see it is how to understand the constitutional principles that would protect our privacy and balance the need for national security and privacy on the one hand, and what does that imply about our treatment of non-Americans as we move forward with our needs of national security abroad.
Fascinating. The citizen, non-citizen distinction is important. And in fact, I said when I talked to this amazingly moving naturalization ceremony that by becoming citizens, the people in this room just a few hours ago achieved rights against the possibility of surveillance that they didn't have before they were citizens.
That's right.
So and I want to zero in on that, especially when we talk about targeted killings. But let's just jump in and have at it, panelists. So here's the scenario. It doesn't sound all that hypothetical. The government suspects that someone is a terrorist, and without a warrant, let's imagine it takes a tiny drone camera, this is the FBI doing this, not the NSA, and follows this suspect 24/7 for a month, follows his movements 24/7 for a month. The relevant case law, I guess I can offer in wearing my teacher hat. I suppose the leading case would be United States versus Jones. This was a case just a few years ago where the police suspected a guy of dealing drugs and put a GPS device, a global positioning system device, on the bottom of his car and followed his movements 24/7 for a month. Based on this surveillance, they concluded that he was indeed dealing drugs, and he was arrested and convicted. He objected that the evidence should be excluded because there was no valid warrant before the GPS device was affixed. In fact, the police had gotten a warrant, but they were supposed to start tracking him within 10 days. They started on the 11th day. They were supposed to only follow him within D.C., and they followed him in Maryland. So the Supreme Court had to assume that there was no valid warrant. And the Obama administration took the rather aggressive position that there was no need for a warrant for 24/7 surveillance because, as Carrie signaled, citizens have no expectation of privacy in public places. And we have to assume the risk whenever we step out in public that we're being followed 24/7 by the government. In a unanimous and to some surprising decision, the Supreme Court disagreed. It rejected the position we have no expectation of privacy in public, but the justices divided on the reasoning for doing so. 5 justices, led by Justice Antonin Scalia, said the problem was physical trespass. The fact that the police put the device on the bottom of a car and interfered with the suspect's property rights and also had to trespass on his driveway to do so meant that the framers of the Constitution would have considered it a search because any physical trespass to achieve information would have been considered a search. 4 justices, led by Justice Samuel Alito, said a physical trespass wasn't necessary. It was the amount of information that could be revealed by 24/7 surveillance. The rallies we attend, the political movements that we associate with, the bars that we visit, that was information in which we did have an expectation of privacy because we do have an expectation of privacy in the whole of our movements, and therefore a warrant was presumptively required for month-long surveillance, but not for day-long surveillance, and if the cops weren't sure, they could get a warrant. All right, that's my nonpartisan summary of the case. Justice Sotomayor had a concurrence, interestingly, saying the whole problem was the series of legal doctrines that Carrie alluded to that say that when we surrender data to a third party for one purpose, we abandon all expectation of privacy in it for all purposes. If that were taken seriously, Justice Sotomayor said, anytime our movements are recorded in public by digital devices and stored in distributed databases in the cloud, then we'd abandon all expectation of privacy in it because we've surrendered the data to the third party like Google and Yahoo. So with the Jones case in mind, Carrie, let me begin by asking, what would the current Supreme Court say if the FBI were to start using drone technology to track suspects 24/7 for a month without a warrant?
Well, I think the way that the decision was issued perhaps makes the answer to that a little bit unclear, because the majority, it was a unanimous decision, but as Jeff said, the majority part of it ruled on this sort of common law trespass. They didn't make the judgment that there should have been a warrant on the fact that they found an expectation of privacy in the activity of the GPS surveillance tracking the person's movement. The 4-person minority concurrence, I guess would be the way to say it, said that they would have decided the case based on this expectation of privacy. So I think what we see that maybe in the future the court might go down that road and find the expectation of privacy, but this particular configuration didn't. That being said, here's sort of how an investigation works and how the scenario that Jeff has laid out would work. So there is, if we're talking about an FBI investigation, and just to clarify one point that had come up a little bit earlier, with respect to non-U.S. persons in the United States, so a non-citizen, you still have constitutional protections. Anybody in the United States has some level of constitutional protections. U.S. citizens or resident aliens, lawful resident aliens, have the highest level of protection. But that doesn't mean that warrantless activity can go on against non-citizens as long as you are within the borders of the United States. So I just wanted to clarify that point when we're talking about inside the U.S.
Just on that, is there any difference between the Fourth Amendment rights of citizens and non-citizens against drone surveillance within the United States?
Is there a difference between how drone surveillance would be applied to non-U.S. persons versus U.S. persons in the United States?
If I'm a non-citizen, do I have less protection against 24/7 surveillance than if I'm a citizen?
I don't think so. No. For a person in the United States, you would get the same level of protection. So if the FBI were required to get a warrant to do a certain activity against a person in the United States, it wouldn't matter who that is, they would have to get a warrant. So how investigations take place is there's a set of guidelines called the Attorney General Guidelines for FBI Domestic Operations, and those guidelines have lists of investigative techniques. And depending on the level of intrusiveness of the technique, a different level of either administrative approval or legal process or a search warrant is required, or some type of court order. And so it starts at sort of the low. There's a principle called the least intrusive means. And what least intrusive means is it's a concept that investigators use that unless there's some reason to jump ahead, which could be the case in a terrorism case like you're describing, but unless there's some reason, generally investigators have to start with sort of the basic level of investigation that does not raise significant levels of expectation of privacy. So traditionally, this included physical surveillance, which is what you picture when you're thinking about a TV cop show, where they're sitting in their car and they're drinking coffee and they're watching sort of the suspect down the road. That's physical surveillance. It's a law enforcement officer watching a person out in the public do some type of activities. And then you can picture in like the old 1970s or 1980s police cars where, the Cadillac sort of goes around the corner and is watching the person. That's physical surveillance. Drone surveillance is sort of a sophisticated version of that. Now, physical surveillance would fall into the lower intrusive level of technique. And then as we move up the ladder, you'd go physical surveillance. There's a technique called a mail cover, where it would just be sort of looking at the front and back, looking at somebody's trash. These are considered sort of low-level investigative techniques. As you go up the ladder, you go to Penn register or trap and trace surveillance or requests for records. Penn register, trap and trace is the to and the from of who you call on the phone. Records can be obtained depending on what type of records they are under different statutory provisions or from a subpoena. And then when you get to things that are the highest level of an expectation of privacy, like the content of our phone calls or a search of our home, that requires a warrant. And so what these cases, I think, are doing is they're sort of taking what was a very low intrusive level activity, the physical surveillance, and at least the minority part of the court that's saying now if a drone is conducting it for a long period of time on a continuous basis, they want to flip it all the way up to the highest level of scrutiny, which would require a warrant. And that's a fairly dramatic change for investigative technique.
Claire, do you agree with Carrie that you would need a warrant for month-long surveillance by drones in light of the concurrence in the Jones case? And after all, Justice Alito said, it all depends on what citizens actually expect. If we got to a world where drones were ubiquitous and where the government said, watch out, you have to assume the risk that you can be tracked by drones at any time, wouldn't then our expectations be diminished and we would lose the protection against 24/7 surveillance?
Yeah, I think, though this is not my area of expertise in the way that it is Carrie's, it does seem to be likely that you do need a warrant in this sort of case. The disturbing thing that I find is that, as has always been the problem with the Fourth Amendment and the exclusionary rule, is that the privacy is protected only with regard to criminal suspects who are trying to suppress evidence that is needed for their own prosecution. Whereas the issue of privacy and drone surveillance and cell phone information and internet information doesn't just affect criminal suspects, of course. So the exclusionary rule has long been a problem in that regard, which is that, first of all, imagine the police storm into your house without a warrant. They conduct a very aggressive search. They find no evidence, and they leave again. What remedy do you have? Well, you don't really have any remedy. Certainly you don't have any remedy under the Fourth Amendment, because the Fourth Amendment only tells you that you can use the fact that the search or the seizure was illegal as a grounds for keeping that evidence out of court in a criminal case if you're a criminal suspect. What if you're not a criminal suspect? Right? What if this search occurs for other reasons? Maybe you're a witness. Maybe someone you live with is a criminal suspect. Do you have any remedies in that case? Not particularly. So this issue of whether or not you need a warrant is an enormously important one to resolve. But it's just the tip of the iceberg as far as the enormous expansion of invasion into privacy that we've learned about in the last several months that needs a more general solution.
Well, that is a great challenge. You're absolutely right that if you're an innocent citizen who's never arrested, then you have no evidence to exclude, and therefore it's hard to challenge. There's also the problem that the surveillance may be done not by the government, but by Google, as my friend at Google imagined. It's Google and Facebook who have more power over free speech and privacy than any president or king or Supreme Court justice. And if Mark Zuckerberg decides that it would be really cool to put live feeds from Google Glass onto Facebook, because you could check up on your friends and learn cool stuff, and starts up an app, along these lines, I can't assert the Fourth Amendment because the Fourth Amendment only binds the government. It doesn't bind Zuckerberg. So what then? Do we need a new right of public anonymity that would bind Google as well as the government? And should the Constitution be amended to protect it?
Well, it's interesting. There are uses. I'll come back to the private sector piece in a minute, because that also comes into play in some of the electronic surveillance debate that we've heard about this summer. But there are positive government uses, aside from conducting investigation, that drone surveillance can be used for. So, for example, Customs and Border Protection can use drones to monitor border activity, either on the southern border with Mexico, or they can use it on the northern border. Drones have been used to support Department of Homeland Security disaster and disaster recovery events, hurricanes, floods, things like that we wouldn't necessarily think of. And so there are positive government uses of drones where people might be okay with that use, and it certainly wouldn't seem quite right. Certainly not. I don't think the court was going in this direction at all. That the government would have to get a warrant for that type of activity. That's sort of in the public good, and the information is being used to do protective things. I can see sort of more use of it down the future as well in terms of border protection, maybe human trafficking. So there's things that the technology does provide us more ability to do positive things on behalf of the public that is useful. The private sector versus government use of information has come up a lot in the electronic surveillance debate as well. There are privacy policies, so every time when you use a Google or some other type of internet service provider, there are privacy policies that when you sign up to use them, you click and you say that you consent to whatever it is that they're doing with your information. People in government have frequently thought that the private sector has quite a bit more information on the American public than government does, and government is only using it for sort of specific investigative reasons, either national security reasons or criminal investigative reasons. But it's true that the private sector has access to a wide range of information, but so far government has stayed out of it, and I think my own view is that is sort of more appropriately negotiated between the public and the private sector.
If I can just inject maybe one thing here. It's important to see how much the concept of privacy has changed over the years. So if you go back to a 1960s case, Griswold against Connecticut, and there, that was a case where Connecticut had passed a statute banning the use of contraceptives. And the question was whether or not that was a violation of privacy. And the arguments were that it is, in a sense, the government stepping into your bedroom and telling you what you can't do in the privacy of your own home. But notice there's no physical invasion in that case. So the idea that it's even a debate whether or not there has to be physical invasion for your privacy to be violated, or whether or not drones can violate your privacy by gathering information sort of from a distance, is really a puzzling one in the history of the concept of privacy. And actually, we have a very different conception of privacy when we're talking about information gathering than the older notions of privacy, which don't play as much of a role anymore in constitutional law, which is about more freedom of choice or freedom of decision with respect to one's own values. So I think it's important to keep those two notions separate.
Beautifully put. You're absolutely right. American law has traditionally protected privacy in terms of private property and trespass, and now we're talking about a different right, a right of anonymity, of autonomy, a right to control how much of your thoughts, emotions, and sensations are communicated to others. That beautiful phrase came from the words of my great hero, Justice Louis Brandeis, the greatest defender of privacy in the 20th century. Whenever I have a bust of Brandeis in my office downstairs, whenever I have a hard privacy question, I ask, WWBD, what would Brandeis do? And in this case, just as Claire suggests, I think Brandeis would have been impatient with these formalistic focuses on physical trespass, just as he was when he objected to the court's refusal to require a warrant for wiretapping in the 1920s, and would have insisted on translating the Constitution to protect the same values that the framers took for granted in light of these new technologies. Now, how he would have articulated it, I'm not quite sure. I think it might have sounded like a right of public anonymity, or a right to control how much of your emotions and personality are communicated to others. It would be a stretch. It's not clearly located in the existing doctrine, but it seems to me that if we are to have the same amount of privacy today that the framers took for granted, some kind of Brandeisian leap might be necessary. All right, well, that's a good discussion of the crucial issues raised by drones. Let's turn to the question of targeted killings. Claire, you are the world expert on this. Why don't you tell us a bit about the Nasser al Alaq case, how the government decided to target him for assassination, what procedures were used, and what the state of play of the debate is right now.
Well, Jeff, first let me add my thanks to you as well, and to say how delighted I am that you have become the director of the National Constitution Center, and that we have you now in Philadelphia. The center that I direct, Center for Ethics and the Rule of Law at University of Pennsylvania Law School, is also a nonpartisan center. And while we don't necessarily focus uniquely on constitutional issues, the spirit of nonpartisan debate about foundational issues relating to the rule of law is such an important thing. So I so much salute what you're doing here. So the topic of targeted killing and drones is, of course, bear important resemblance to one another, because drones are often used in targeted killing. But it's important to keep these two topics somewhat separate, because targeted killing is not just done with drones. Drones is, as Carrie said about surveillance, just another method of engaging in the underlying activity, which is targeted killing. On the one hand, targeted killing is something that no one can really object to in war, because the opposite of targeted killing is untargeted killing. And certainly that's not what anybody wants to see in war. So warfare, legitimate warfare, has always involved the use of targeted killing, and the more precise that you can be in that killing, the less collateral damage there is in conducting military in engaging in military exercises or meeting your military objectives. On the face of it, then, drone technology, which increases the precision with which you can engage in military activities, is potentially a good thing, because you can reduce the amount of collateral damage. Now, we've heard a lot of talk about drones and collateral damage, and there certainly has been collateral damage in the use of drones. However, if you compare that to the collateral damage involved in, say, fire bombings, when we engaged in fire bombings of Dresden, for example, during the Second World War, it's almost all collateral damage. Right now, that was very controversial military operation. People have different things to say about it. But if you engage in aerial bombardments, which cover a large territory, even if you have a very well-defined and legitimate military target, it's really hard to keep the damage confined to that target. So precision technology is a good thing. However, and this is a big however, how do we decide who goes on the targeted killing list, the so-called JPEL list, the Joint Prioritized Effects list? In 2010, it came as a leak to a man named Nasser al Alaq that his son, who had become a Muslim cleric and was living in Yemen, was on the JPEL list and was designated for killing on that list. Once an individual is placed on that list, they become a regular object of operations designed to target them, to take them out, and they will remain on that list regardless of their conduct, and they will therefore remain a target unless they are actively then reviewed and removed from that list, which, as though we don't really know, we don't think that usually happens. And once someone is a named individual on that list, then there will be efforts to either capture or take him out as a target, regardless of whether or not he is actively posing a threat at that moment. So he could be sleeping, he could be in the bathroom, he could be watching a movie. It is not based on his particular activity at the time. It is based on his status as an individual who is identified as posing a threat to our national security. So Nasser al Alaq, we found out that his son was on this list, and he filed a motion for an injunction to have his son removed from that list. The D.C. Circuit eventually decided in December of that year that Nasser al Alaq lacked the standing to bring his son's situation to the court. Nasser al Alaq particularly was claiming that his son's due process rights were being violated because he was, in a sense, sentenced to death without advance warning of possible offenses, without being able to confront his accusers, without the benefit of an attorney and a trial and all the things that normally go along with being a criminal suspect and eventually being sentenced to die in a state, say, that has the death penalty. The D.C. Circuit said that whether or not there was any due process violation was not something that the court was able to reach or discuss because of something called the political questions doctrine. And that is a doctrine that says this issue of whether or not al Alaq, the son, could be on the JPEL list and could be targeted, is constitutionally committed to the political branches, i.e., it is a matter for the executive branch, for the president to decide, or is it a matter for Congress to decide in conjunction with the president, but the courts have no ability to look into this question. Now, since the place that due process rights have always been vindicated and heard is in Article III courts. That's where you expect to be able to bring a due process claim. So that essentially shuts down, if you agree with that logic or if that logic carries the day, it completely shuts down a judicial review of targeted killing challenges. In addition, some rather more recently, you may know that something called a white paper on this topic was leaked to NBC and then was disseminated. And in that white paper, it appears that there was, as we knew, a memorandum written around the same time by some lawyers in the Office of Legal Counsel discussing the Al Alaq case, or at least the scenario involved in the Al Alaq case, and the question of whether or not American citizens living abroad could be targeted. The lawyers for the Office of Legal Counsel said that they could be, under certain circumstances, laid out those circumstances, and said something very important, which is, and this is non-reviewable by Article 3 courts. So we had both the administration and the D.C. Circuit conjoining to say that due process claims involved, that might or might not be involved here, could not get a hearing in a federal court. And I think that's an issue that requires really careful examination, since it sets a precedent for taking what is the traditional way that constitutional rights have been vindicated really out of the picture.
Thank you. Extremely concise and effective summary of some very complicated issues. You've put two legal questions on the table. Is there a constitutional right to be free from targeted killing, a due process right, or maybe a Fourth Amendment right? And second, can courts review it? So let's focus on the substantive question first. This white paper that Claire referred to makes the following case on Fourth Amendment grounds. It notes that the U.S. Supreme Court has previously held that the police can use deadly force against fleeing dangerous suspects when killing the suspect is necessary to prevent the escape and the officers have probable cause to believe the suspect poses a significant threat of death or serious physical injury. But the white paper expands that precedent. It says you don't need clear evidence that there's a specific attack on a U.S. person in the immediate future. Instead, the claim is that a decision maker determining whether an al-Qaeda operational leader presents an imminent threat of violent attack must take effect of the fact that members of al-Qaeda are always plotting against the U.S., and the U.S. may not know about all the plots. So really, this is an expansion of the whole idea of imminent threat. Carrie, is this a persuasive expansion, or has the administration overread these earlier cases involving fleeing felons and ordinary law enforcement to create a vision that arguably clashes with the Fourth Amendment?
Well, I'm not sure that I think that that sort of the central argument of the white paper hinges on the Fourth Amendment piece and sort of making the analogy to law enforcement. I think so the white paper was sort of it wasn't the actual official legal memo that the Justice Department would have relied on, but it was sort of a summary of their legal theory behind why this targeted killing policy is lawful. And I think they were, in using the Fourth Amendment example, they were trying to sort of cover all their bases and so show, even if this were a law enforcement example, this type of activity is still permissible. But I think their stronger argument, and so for those people who and certain from the government's perspective, believe that courts don't belong anywhere near these targeting decisions, is the constitutional argument that this is commander-in-chief responsibilities. This is not necessarily a Fourth Amendment issue. This is commander-in-chief responsibilities. We are in an armed conflict with al-Qaeda. In October of 2001, Congress passed what was called the Authorization of Use of Military Force, and the justification for targeting an individual who is a senior operational leader of al-Qaeda or associated forces is a military decision, ultimate decision by the commander-in-chief, and any due process that that person might have had is sort of negated by the fact that they are planning attacks against the United States.
So let me disagree with you on one point, which is the AUMF is really not as significant here as you might think, because the AUMF did not tell us who is a combatant and who is not a combatant. And it's that distinction that's so crucial. So under the law of war, if you are a combatant and you're in an armed conflict, other combatants have the right to kill you 24/7. You don't have to be dangerous. The threat doesn't have to be imminent. That's what it means to be in a war and have the ability to kill as a combatant, have the privilege. However, ordinary citizens, ordinary civilians can never be killed in war. They cannot be targeted. They're sometimes accidentally killed, but they can never be targeted. And this principle is known as the principle of distinction, very, very crucial principle on which our just war theory depends. The question is, are members of al-Qaeda combatants or civilians? And this is where the intersection between criminal law and military law becomes very complicated, because on the one hand, we know what a combatant is, but a combatant has historically been a member of a governmental force. We know what a band of criminals looks like, right? That even in a very large scale, take the war on drugs. You have very large criminal bands. What do you do with a large criminal band bent on destruction that seems to require from us a level of response which is military in nature, but which is not a member of any governmental organization? So what we did is we called these individuals unlawful combatants. But that's not a category that we traditionally know from the principle of distinction. And it's really that issue that the AUMF doesn't speak to, and that's the heart of the problem here.
Does that novel category introduce due process concerns too? Al-Awlaqi's father said he's never been adjudged to be a member of al-Qaeda, let alone convicted of any crime. No judge has reviewed the fact that he was placed on this list. There's no possibility of getting off it and no appeal. This is a violation of his right not to be deprived of life or liberty without due process of law. Substantively, is that a convincing argument?
Well, to some extent it is, because if we had a clear status of combatancy here, then it doesn't matter if you're an American citizen or not. American citizens don't get to go to war against their own countries and claim, well, I have due process rights here, you can't target me. That's not okay. It doesn't matter whether you're American or you're not American. If you go to war against the United States, you can be killed as a combatant. If what we're dealing with, however, is some kind of half civilian, half combatant status, then the claim, hey, I have due process rights, starts to look a lot more plausible. In particular, I should be treated like a criminal and have the same due process rights that I would have if I were accused of a crime, starts to get a hold, at least is a reasonable claim. So the question is whether or not we should think of members of al-Qaeda, or as you say, he was really, as we say, al-Qaeda on the Arabian Peninsula, this sort of broader group of terrorists, suspected terrorists, who are affiliated with al-Qaeda. It's not membership in al-Qaeda per se, but it's the fact that they pose a threat to the United States and are engaged in furthering the activities of al-Qaeda or associated forces that gives rise to the idea that they are some kind of combatant. But we don't really have a long tradition or a body of law that allows us to identify that status with any certainty.
All right, I'd love your thoughts on the due process question and also the proposal by some, including Robert Gates, the former Pentagon chief, to create a drone court that would review the White House's targeted killings, would decide who was on the list, and might even decide when the assassinations could take place. Are there due process concerns, and if there are, might a drone court address them?
Right. So the drone court has been proposed in sort of a variety of circumstances. Some of the proposals have to do with that it would only apply to targeted killing drone strikes against a United States citizen, which so far is a case of one. So the Alaqi example is the only example that we know of where the targeted killing drone strike authorization has been given against a U.S. citizen. There have been a number of other drone strikes that have sort of started, I think, circa 2002, and then slowly increased, and then since 2008 have actually substantially increased, and they've migrated from sort of Pakistan and then Yemen, and then now there's a question as to sort of how far out into other areas where al-Qaeda or associated forces may exist can we use this targeted killing policy. But with respect to the drone court, so the drone court, so one idea is that it would only apply to a U.S. person. There are other proposals that would expand it to making a determination as to sort of all persons who are placed on this targeted killing list. At a fundamental level, as I mentioned earlier, there is a strong argument that this is not a judicial matter. This does not belong with the courts. This is a executive branch, commander-in-chief. These are military decisions. And if we take the drone out of it and just talk about, we're talking about a lethal action against a al-Qaeda or associated forces operative planning attacks against the United States, that is a counterterrorism activity, which post 9/11 we have moved out of the law enforcement model into a military and intelligence approach. And so one argument is that, number one, this just doesn't belong in the courts. This is commander-in-chief responsibility. At a practical level, and from this I draw on my experience with the Foreign Intelligence Surveillance Court, I think that there are concerns at a very practical level as to what this means, what a so-called drone court would mean. In the FISA court example, what we've seen, this is the Foreign Intelligence Surveillance Court that has existed for over 30 years and rules on national security, wiretap, and search applications. And over the years, the FISA court has gotten more and more involved in terms of the how a particular surveillance occurs. And this is evidenced in the court has actual rules, just like a regular court. They have unclassified rules that are published. And one of the things in those rules says that when a new technology is used, the government needs to provide a brief and explain how that technology is going to be applied. I think that piece could be potentially problematic when we're talking about deploying what is a weapons system. Because how far is the government going to be willing to go to explain to the court how it does things? And my point is that once you get a court involved, then the government would have to satisfy the court whatever it wants to know, basically. And so, because these would be judges who would be appointed to the court. If they follow the FISA court example, it would be Article 3 judges assigned to be on this special court. And so, in order for it to be legitimate, you would have to satisfy whatever the court would want to know. So perhaps the court would want to know more information about collateral deaths or the precision of the technology or what the future of precision of the technology would be. And it can get very granular. And I don't think that when we're talking about what are either military operations or intelligence activities, that is a place that the government really would want the court to go.
Well said. We're going to do audience questions in a moment, but Claire, would a drone court address constitutional concerns, or is it a bad idea?
My own view is that it's a very bad idea. There's a tendency in this country to say, when we don't know how to solve a hard problem, and it has to do with legal or constitutional rights in general, to say, let's make a special court. And there's a long history of that. There's a long and very bad history of that, of course, because the Germans in the Third Reich invented a lot of special courts. Now, I'm not saying that there's any sort of similar motivation going on in this case, but it tends to be a way of burying problems rather than bringing them to light in light of existing legal concepts that we have. And I see it as a potential threat to constitutional rights to take issues that impinge and relate to those constitutional rights and squirrel them away in special courts on the theory that special expertise is needed. Judges and juries in Article 3 courts have to deal with complicated fact patterns, complicated technologies. It's a whole other topic, how you educate judges, how you educate juries to deal with those complications. That's crucial. Because I teach in a law school, I'm in the business of educating future lawyers, and I really believe that law students need to be trained in statistics and economics and in all the tools that they're going to need as members of those courts to deal with the technical issues. It's not as though that kind of education is impossible. It's a responsibility. So rather than tucking these questions away in special courts, I think that we have all the resources in Article 3 courts that we need to deal with the constitutional questions that arise.
Great. So agreement that drone courts are a bad idea, although disagreement on the reasons, which is very much in the NCC spirit. We have a few minutes for questions, and here's the first one. Congressman Bob Barr has sent out a map of the secret drone bases throughout the United States. Why do we need all these drone bases? What is their purpose? Carrie.
Well, I haven't seen the drone map, so I can't quite picture, although there's a very good explanation. Peter Bergen, who's an al-Qaeda expert, provided testimony on the Hill in recent months and really provided an outstanding summary of sort of all of the drone activities. I'm not a military person. I don't know that I can speculate sort of why we need the drones where they are. There have been drone strikes that we know of in Pakistan, in Yemen. I think we've started to see at least one in Africa. And so there are, al-Qaeda is a living, breathing network. And it shifts. And it shifts to areas that have weak governments. It shifts to areas that it thinks it can set up operations and act without government scrutiny of its host country. And so I think we will actually probably continue. If the drone program is to continue, I think we will see bases in different areas based on the areas of the world where al-Qaeda and its affiliates reside.
In terms of targeted killings, does it meet opposition from other nation states, especially in the expectations of treaties, norms, and use Kogens? Claire, first of all, explain for the non-initiated what use Kogens is, and tell us, are drones killings opposed by other countries?
So use Kogens is literally translated, the known law. It's that implicit law that we take all countries to be committed to, and it has particular importance in the area of human rights. So that even if a country is not signed on to a treaty, we may say that this country has to be held to the standards of human rights that we expect all countries to live up to. And the explanation for that might be use Kogens. I think it's very, very tricky whether or not other countries need to agree with our use of targeted killing in order for that to be legitimate. On the one hand, we have very much in the past isolated ourselves from our allies in Western Europe, and that has cost us politically and legally to some extent. We have sacrificed some support. On the other hand, sometimes you have to sacrifice support to stand up for your own security and possibly for principles that others are not willing to stand up for. I think that the recent rejection of the president's initiative with regard to Syria may be an expression of some of the loss of support of our European allies. Diplomatic efforts to bring other countries on board are always important. But after all, if the drone strikes are geared towards our national security, we have, to some extent, a right to engage in them if they don't violate other principles of international law.
Wonderful. Last question, an interesting one. Does drone use by the government violate the posse comitatus law, either the letter or the spirit of the law? What's the posse comitatus law, and does it violate the letter or the spirit?
Well, the use of the military within the United States, I think before when we were talking about within the United States, it's law enforcement that is using the drones. And so we've had the FBI, which is a federal law enforcement agency, acknowledge their use, and we've had Customs and Border Patrol acknowledge their use. And so they have guidelines for how they're being used. But again, these are all under sort of law enforcement or with the Customs and Border Protection, sort of homeland security type reasons.
Thoughts on the use of military techniques within the U.S.?
So the difficulty is, again, that we have these two distinct arenas. We have criminal law and we have military law. One of the questions that I often ask people is, what would you think of a strike against an American targeted killing that took place on U.S. soil? Whatever you think about the killing of Anwar al Alaq in Yemen, place that case in Cleveland. And then ask yourself, would you rather have al-Alaq pursued by law enforcement officials or by military personnel? That makes the clash of these two jurisdictions very sharp. And one of the concerns that I have is that we are undermining our law enforcement capacities by placing more and more under the military umbrella rather than allowing law enforcement to serve its traditional function.
All right, well, I said at the beginning of this debate that I wanted to present you with all sides of these complicated and fascinating arguments and let you make up your own mind. So we're now going to have a constitutional vote, ladies and gentlemen, if you don't mind. And remember, I'm not interested in your political views about the policy merits of the surveillance or targeted killings we've been discussing, only in your constitutional views. And this is basically the question. It's a paraphrase of an excellent question offered by Salvatore from Philadelphia. The question is, can the government surveil a suspected terrorist 24/7 without a warrant? Who thinks that consistent with the Fourth Amendment, the government may put a drone camera on a suspected terrorist and track his movements 24/7 for a month? In the United States. And who thinks that the government needs a warrant to track a suspected terrorist 24/7 for a month? All right, the skeptics have it, but there was a vigorous representation for both sides, just as we hoped for, at the nonpartisan National Constitution Center. Ladies and gentlemen, if you're here at 5:30, we're going to continue our wonderful series. I guess it'll be cocktails and conversations on the Defense of Marriage Act. Please join me in thanking our panelists for a great discussion.